All right, it's time for another episode of I Hate Real Estate. Hey, haters, and hey, Kendall.
Hey, Jamie.
It's good to see you.
You too.
It's been a long time.
It has been.
So
you're wearing the awful Texas color today.
Listen, horns down in their color. I hope you guys are watching this in Texas. It's us, your dad, Arkansas. Oh, sorry. I'm just being very hateful. It's not my fault. It's not my fault. We finally have an incredible basketball and football team in Arkansas. Our fan base has been waiting.
And
years.
baseball.
Baseball's always been good. Come on. That's like same thing as UALR's women's soccer team. Nobody gives them credit either, and they're the best in the world. But anyways, moving on. So, haters, we're here to talk about something that real estate agents do on the regular that they shouldn't, correct?
Yes.
It's called the unauthorized practice of law. And my good friend Kendall, real quick, I need you to break down for me exactly what it means to be an attorney versus a broker, right? Because people just want to write agreements. I'm a broker. I can write an agreement. But there's a difference between writing an agreement as a broker and practicing law. Can you explain the difference to me?
Yes. The agreement that you're writing when you're going through and checking boxes and putting an address and writing people's names in is on a document that was drafted by an attorney. It's pre-drafted for that very purpose. Adding things to that document above and beyond what's already there is a problem, because I hate to sound
Actionable
that
offense,
way.
actually.
I hate this, but the difference in an attorney and someone that's not is that an attorney has a license to do those things, to draft contractual provisions, because there's an understanding of you have to look at everything from every circumstance that could happen, both good and bad. We have to assume the best and we have to assume the worst, and we have to hit every scenario in between those. Well, if you're just writing in a provision that some client wants you to write in about, hey, we need this certain list of names of people that you don't get a commission if the property sells to those people. Well, let's write you do that, and then you don't come across the worst case scenario of, well, what happens if there's a disagreement about whether this name should or should not have been on there? Or what happens if this person actually didn't know that the property was for sale, and me, the agent, I'm the one that told them, but their name ended up on this list, so now I don't get a commission. And all of a sudden you get in a fight and there's no contingencies. There's no terminology in there for what would happen in the worst case scenario or if something came up. And that's
Which means
the
you have
problem.
no recourse. But then also, what you just said about a problem, it's actually an actionable offense, right?
Yes.
I mean, I literally Googled this because I thought, well, I'm going to look on Arkansas State, our websites and stuff. But when I just Googled the unauthorized practice of law, for some reason, Google popped in is punishable by, and it literally says you can face possible jail or prison sentence, and a misdemeanor conviction can lead to a sentence up to 1 year in county jail. I don't want to hang out there.
It's the same type of thing as impersonating a police officer type of deal.
That's illegal.
Yeah.
I'm just kidding.
In that circumstance.
And
it's not on Halloween.
Yeah, so when you go for a cop on Halloween, you can't actually pull people over, FYI. No. But this being said, for real, on arkansascourts.gov, there's actually an article about this. They have a committee on the unauthorized practice of law and an FAQ that's associated with it. So the practice of law in Arkansas, there's not a precise definition of the practice of law. That sentence cracks me up, but it also alludes to what you just said. The most analytical career in the whole wide world, which I used to think was appraising, is the practice of law. And it's because you really do, like you said, good, bad, and different, have to see every scenario, but also be prepared for the recourse in every scenario. So what about, and let's just go back to, I know that you're a big fan of the guy who wrote them, but our contracts, and tell me exactly when you say that they are drafted by an attorney, tell me how these contracts came about.
Because of this very issue. You had scenarios where every transaction, the way it was going, was either you had contracts that were being drafted by the people that were involved in the contracts, which was causing issues in the legal system. And likewise, you also had the unauthorized practice of law, because if you had LLCs, if you had entities like that were drafting these contracts, they're not allowed to represent themselves. We mentioned that briefly on a previous show, that a company can't represent itself, period. Now, I say that. The real reason that the documents got drafted is to protect real estate agents and real estate agencies and brokers from their clients' contracting habits of being bad, and in turn causing realtors, real estate agents, and real estate agencies and brokers to get dragged into lawsuits that they otherwise should not have been involved in. And in some circumstances, being liable in those contracts, in those lawsuits under those contracts when they otherwise shouldn't have been. And so truly the main purpose of these documents is to simplify the process. It makes it where anybody that has a right to use those forms, because they are copyrighted and they are pay for them, and they are pursued if the copyright violation is discovered. I've seen it happen. It's not just a copy it off the internet and use it for yourself. They even punish people that use the exact language from the forms in their own contracts. It's completely copyrighted. But the purpose was to simplify it, to make it where a lawyer does not have to be involved in every single transaction, so it saves costs for the parties, and it relieves liability for agents, agencies, and brokers.
So when I practiced real estate in another state, I can tell you 100% that it was way more difficult when it came down to contractual obligations as somebody who was initiating those contracts, because I'm going as a real estate agent to a broker, and at the time actually property management as well, and these agreements are being written by those people. At the time I wasn't experienced enough to have my own brokerage or be my own broker, so I had supervisory people in those positions. However, it wasn't fill in the blank, I can tell you that much. There was a lot more information that had to be included in that. And if you're listening from another state, what Arkansas has is actually, we are a model state when it comes down to these contracts, and I'll let you talk about that a little bit more and brag on them, because it's something we have a point of pride. I mean, up on these copyrighted contracts, all we have to do is fill in the blank. As you mentioned, it's literally check boxes and name, address, legal description, terms of the contract. I think, in my opinion, the most dangerous 3 forms or areas of form that we have is item 30 of the real estate contract, which is a blank space that says other, inviting you to make this mistake. Secondly would be the general addendum, which is a blank sheet of paper saying, here's some stuff I want to do. And then the third would be the counter to the real estate contract, in my opinion, because as well, the counter can issue, demands that are not appropriate. Now, let me go ahead and tell on myself here, but you're already aware that the last counter I wrote included a term that said, hey, the attorney's going to draft a bill of sale. Now, this is not something I did wrong, but it's something from the mortgage lending perspective
that they don't approve,
that they don't like. And so you really have to think about, from everybody's perspective, what these contracts look like, because my counteroffer said, well, hey, ancillary to the contract, there will be a bill of sale, because I know that if I write a bill of sale, it's going to be the unauthorized practice of law, because I cannot write a contract in the state of Arkansas. So back that up to, first of all, what is a contract?
It's an agreement between two parties.
Has to be
a promise
drafted,
for a promise.
And has to be drafted by a licensed attorney, right?
It doesn't have to be if you do it individually, but it should be.
But if you're an entity, it does.
If you're an entity, it does.
And if you practice real estate in the state of Arkansas, you can't even do that. You either have to have an attorney do it, or you have to use an ARA form, correct?
Correct.
See how upsetting this is? You could really mess yourself up here. But when it comes down to unauthorized practice of law, people might say that adding a piece of information to item 30, saying perhaps along with this contract, the Chevrolet Stingray in my garage is also going to convey with the property for $5,000. So let's say that happens, and we break down the scenario to closing day occurs, and somebody that owned the house took the Stingray out for a drive prior to closing, and they wrecked it, and then they parked it right back in the garage, and then they close on the property. I don't know why I picked a Stingray. I should have picked a Nova. Point is, they come back, and now they've closed. They've paid $5,000 and then they open the garage and the car is damaged. So now there's all this recourse, right? That has to happen. Talk to me from the very beginning. If you're in that situation, what's your first piece of recourse, and what happens when you get to the court or the attorney and figure out that you as the agent put that into item 30?
Yep. There's a lot of problems with this.
Break it down.
So the first one being, if the only language that you said is that the Stingray conveys at $5,000, there's nothing in there that says that it has to be in the same condition. Just the fact that it was damaged by someone, there was no provision added that said you're not allowed to use it between now and then. You have to maintain insurance on it between now and then. If anything occurs to it, you have to file an insurance claim.
Wouldn't have thought about the insurance.
There's all kinds of different provisions that would go in. Under the way you drafted it, technically those people are hosed because the Stingray is still in the garage.
It might even be an animal Stingray. It might not even be a car. It doesn't matter what it is.
It doesn't matter what it is. If it's if it's an animal called Chevy Stingray, then there you go. You got it. But it's that's the major problem for me, is that you have such an ambiguity with that phrase of the Stingray in the garage will convey at $5,000.
And people do it all the time, though, and I've seen it in contracts. Mm-hmm. The dishwasher conveys. Maybe not that one. Maybe they pull that dishwasher out and put a crappy one in there and you get the crappy one. Or refrigerator conveys and it's stainless steel, but you show up the closing day and it's a white refrigerator that's a standby stand and it's not the same one.
Yep. So here's the other problem. Let's say you do have a cause of action. What contract is your cause of action under?
Well, I would assume it would be under the Arkansas Real Estate Association contract.
It would be. Well, where do those terms discuss what happens in the event of damage to personal property? To my knowledge, there's not anything in there.
That's a good point.
There's a loss of use paragraph in there, but that's with respect to the property. If it's damaged by fire, tornado,
still
condemnation,
real property, though.
Yes, but it's all about the real property and the ownership of the real property, and it doesn't even assume any personal property insurance is there to cover that risk of loss. It would be the real property insurance, your homeowner's insurance.
Right, which typically doesn't cover stuff like that. And what's interesting is, let me back that up to those of you who are not familiar with what this actually means when it comes down to writing in this contract. So if you're a brand new agent, you've never done this before, when you go into a transaction where a buyer or seller wants to also get rid of some specific item that is not an attached fixture, which we'll talk about attached fixtures in just a second, then it is not going to convey at $0 for $0 in the contract appropriately. Correct? That should not be in a contract. Am I right?
It should be a separate contract.
Right. So those of us, I've done this before, though.
I've seen it done and go through without a hitch as well.
But the thing about snake bites are, like, once it's snake bitten, it stays snake bitten.
Yeah.
And that's my favorite thing that you say, because now every time that somebody starts getting sideways with me on a deal, or I start feeling that feeling of like, oh, there's a snake bite involved, I'm out. I'm going to suck the venom out and I'm out because I'm done. Yeah, it's not worth the commission when you get in those situations. It's just not. It's not worth the commission to end up at the commission. So
I like that.
You're welcome. So this is just a one-liner show. That's what this is.
It is.
The point of the whole situation, though, is personal property does not convey in the real estate contract. One more time. Personal property does not convey in the real estate contract,
There's
no matter what.
There's not a single term in the contract that even talks about personal property.
And the differentiation I want to give to a new agent is real property, which you should have learned in school, though, is the actual... Go.
The land.
And the house.
Improvements on the land. Well, the house is not real property.
It's the improvement, though.
It is the improvement upon the real property. That is what can be sold as part of the real property. The furniture inside the house cannot be.
And fixed equipment. We're going to go to
fixtures, light fixtures, things like that are part of the real property under Arkansas law.
Okay, so let's go through a list real quick that agents are going to be pissed at me for going through this, but I'm going to do it anyways.
Fixtures.
Curtains.
Yep.
Okay, so if you're of window coverings, those are fixed.
Yep. Light fixtures.
Stove.
Appliances except for the refrigerator typically.
Because why? Because
they're usually embedded in something, and the refrigerator is removable from the space.
you remember Alyssa that we had on the show?
Mm-hmm.
She had a built-in side-by-side steel refrigerator in her house, and that was something that we actually wrote into the contract, which, in hindsight was incorrect because we did say it conveyed at $0, but I didn't have to do that because it was fixed.
I think that if you have it built in where it's not easily movable, that it could be considered as a fixture.
And
but
that's technically what the definition is, right? Mm-hmm. It cannot be easily removed.
That it's permanently attached and not easily, or not easily removed.
I've seen
without causing damage to the property.
So I've seen people pull out, like, okay, the big rocks they took out of her yard.
Yeah,
those were fixtures. And then also those, those things that I think Carrie has one of these that, like, the tall, they hold your jacket and your backpack when you come in from school and you put that stuff down. Yeah. Or some people's kids do that. Mine throw their stuff everywhere. But those things, you can't pull those out either. Washer and dryer and refrigerator are about the only items I could think of personal property wise or appliance wise that wouldn't remain with the property.
Things like handrails on the wall that if you have to unscrew it, it's a fixture.
Right.
And now, I mean, if you've got like a bookshelf or something that you have a tether so it doesn't fall over on your kid and it's screwed into the wall, that's not a fixture. But if it's something that would require
or create
damage to get out, then that's a fixture.
That means that I can take those cool screen things with me that you walk in, they snap right shut.
That's right.
But anyways,
shutters. I mean, that's the same as a window covering. Shutters are expensive, and people want to take them with them, especially if it's on a standard-sized window and not a custom fit. You can't.
I'm sorry to interrupt this riveting conversation, but it's time for a word from our sponsor. This episode is sponsored by American Abstract and Title Company. Not only does this place handle most of the real estate transactions that go down in Pulaski County, but they do it with professionalism, and no one has more energy than their fearless leader, Andrew Atkins. If you have any concerns whatsoever about your title work, bring your file over to American Abstract Title and know it's going to close on time and in style. I have used American Abstract Title for more than one transaction in my real estate career, and they are not one of the reasons why I host a show called I Hate Real Estate. Remember, at the end of the day, we don't really hate it, we're actually great at it. So, my friend Andrew Atkins and American Abstract Title is the place for you to close your business. This episode is brought to you by Campbell & Groom's Law Firm. This small law firm has the tenacity to go after the big guy when your HGTV situation doesn't turn out so great. Remember, we started this show for a reason, and these guys know what to do when things turn upside down. Donald Campbell and Kendall Grooms are the Arkansas Trial Lawyers Association Trial Lawyers of the Year for 2019-20, and I'm pretty sure 21's in the bag. Here's another one that I've seen on a lot of high-end property. This happens. The mirrors. Mm-hmm. The mirrors are hanging on the wall, and you assume, but the thing is, if they're hanging on the wall by a nail, you cannot make the assumption that they're fixed at all, right? So that's another thing. If you're selling these houses with these big, huge, first one that comes to mind is the one that I saw a fight over. It was a big, huge, like brass edged mirror. I mean, it probably was, 5 feet wide, and this thing was hanging on the wall by a nail. So when they left and took it with them, the buyers were really angry. They were like, why didn't that come with it? I'm like, well, I mean, it's not in the contract. You have to actually review. And this also goes back to reviewing every single thing in the item in the contract and making sure you understand when you walk through that house the last time or the first time that you make note of everything that you want to convey with the property. And then what do you do when you want personal property to convey? Because as a real estate agent and broker, I'm keeping my mouth shut and letting the attorney say what needs to be done ancillary to the ARA contract in order to convey personal property with the sale of real property.
You just need a separate agreement. You need a separate agreement that says we're including this property as a separate sale along with the transaction contingent upon the closing of this real estate transaction, and it will pass for X dollars or nothing or whatever the negotiated price is. Yeah.
So one of the things I think is important about that, though, is to make the statement that it is a bill of sale. It's not something that you just write on a piece of paper and you say, okay, now that I've executed the real estate contract, I'm going to go ahead and write this down on a piece of paper and all the parties are going to sign it. And then I'm going to create that ancillary opportunity to include it with the contract, send it to my title company, and off I go. Because that is the unauthorized practice of law. Yes.
And there's things, but there's even more detail to that sometimes too, in that let's say that you're going to transfer a hot tub when you sell your property, for example.
Okay.
Well, a hot tub a lot of times may have a 5-year warranty. Well, if you've only lived at this property, or you could have lived at the property a long time, if you've only owned it for 3 years, you have to make sure that you transfer that warranty. And there may be backdoor paperwork where me as the owner of the hot tub, I have to act for the warranty to stay valid. I have to actually transfer it to this other person. Or the other person may want to know that it's non-transferable warranty, that they're not getting a warranty on something that they believe they're getting. You can see where a fight would come out of this, and they would go file a warranty claim a year down the road thinking they've got a 5-year warranty when it was non-transferable. They come back mad at you, the owner, because you never transferred the warranty, didn't tell them.
Or the agent for non-disclosure.
Exactly.
That's the big thing.
Causes all kinds of problems.
Well, I'll be straight with you. Your hot tub was a whole nother thing because I didn't even really think about that at the time. You were the one who was like, hey, Jamie, I can't, and that's one of the reasons too with I Hate Real Estate that I wanted Kendall to help us with some of these things is because you're in the position you are as an attorney for a reason. There's well-preparedness and all this smart. I'm not going to give you too many compliments on the air, but you know what I mean? It's one of those things where as an agent, you really think you're acting in the best interest of your client by mentioning it. You're like, hey, I'm going to make sure that you get everything you want in this house. I'm going to list it.
And you probably are. You just have to do it the right way.
Because what happens when the recourse hits? I mean, explain to me and tell me, kind of walk me through this if I'm a brand new agent and I don't know the repercussions. And we can use my current deal as sort of an example. We have a client who has a house full of stuff, and his option was to have an estate sale and sell everything, or this buyer in particular came in and said, hey, I'll buy it all for X amount of dollars. Now, we got lucky in the sense that this is involved in probate and there's an entire list of everything, so we know how much it's worth and how much they want for it. But if I didn't list that in the contract, which all I did was say the attorney's going to prepare a separate agreement for this, walk me through if I put it in item 30 and then the buyer shows up on closing and there's either something missing and or it's all burned down or there was a flood and it's all damaged. What's the recourse? Kind of what happens from there? Worst case scenario.
Yeah. Well, in your paragraph 30, you need to have that the property conveys at $0 or for no value. That, from your appraisal standpoint, you should understand why that's there from an appraisal standpoint, because
it just doesn't impact the value.
When the contract gets processed by the closing company, it has to account for every dollar that passed through that contract. And so if there's $5,000 that passes through that contract for somebody purchasing personal property, it could be logged in such a way to show up that was the total part of the total purchase price. And thus that inflates the appraisal value, which is can be criminal. I've not ever done one of those, but I've been advised on certain circumstances where you can do things to increase your appraisal value or the appraisal value of a subdivision that you own lots in, something like that. And the FBI, I believe, investigates those.
Well,
instances.
And sometimes people do that. They inflate the purchase price and do a bunch of closing, and they do whatever they can to pull funds off the backside of it so that the purchase price appears higher on the front end.
Now,
and
I
you're
doubt
correct about
that's
that.
going to happen on a $5,000 transaction, but if people were able to abuse that, all of a sudden there would be personal property transactions of $30,000 passing through a contract where there was actually no personal property. It would just be for the purpose of inflating the value. I can see somebody doing that.
It makes me kind of sick to my
do
stomach
that.
when I hear that, though, because from an appraisal standpoint, and that kind of does bring up another thing, appraisers are not competent in the ability to appraise personal property when they're real property appraisers. And I can tell you that from experience. Just because I'm a real property appraiser, you didn't call me on this one to go look at his personal stuff, because that has nothing to do with what I do. So from that perspective, that brings a whole new can of worms up. But what's the worst case scenario for the agent if they actually do execute on item 30 and they say, $5,000 personal property to convey, and they just do it like that, and there's no separate bill of sale, and then everyone gets in a big, huge fight and it blows up and lands on your desk?
Yep. That means you're probably eating your commission on that transaction if something like that happens.
That's not even the worst case scenario, really.
Well,
though.
no, the worst case scenario is that you get turned in for the unauthorized practice of law,
which puts you in jail. I like how I'm just going to the worst case scenario. I just want you to have the worst case scenario, but only because if you do that, that's a lot of agents are out there doing it. And the reason that I think this is really important from a PSA standpoint is agents do go out and they write this in their contracts, and the $0 conveyance is the same thing as it conveys for $5,000. It's all the unauthorized practice of law. The committee says right here that when a person appears before a court of record for the purpose of transacting business with the court in connection with pending litigation, or when a person seeks to invoke the processes of the court in any matter pending before it, the person is engaging in the practice of law. So there's that. And then the practice of law includes any services of a legal nature rendered outside of courts and unrelated to matters pending in the courts, including the conveyance, preparation of legal instruments of all kinds, and in general, all advice to clients and all action taken from them in matters connected with the law. That means even your advice is being taken into consideration.
That goes to exactly what we said, that you can do it yourself. You can't do it for others.
Yeah, I mean, I could, yes, but I can't.
You can write your own contract, but you can't do it for others.
But as a real estate agent and broker, and especially as a broker,
you're doing it on behalf of third parties every time.
And from the broker standpoint, this is another big point for me as far as once you're a principal broker. Now, I am not a principal broker anymore, thank you, EXP. But as an executive broker, it's important for my own contracts that I supervise and understand what's in them. But from a principal broker standpoint, if you're out there being a PB, you need to understand that all those agents who write those contracts underneath you that you sign off on, it is your responsibility as you sign that to recognize the unauthorized practice of law. Am I right? I love it when I'm right. Anyways, moving on. It does say right here who may practice law in Arkansas. So just to clear the air, only a lawyer admitted to practice in Arkansas is allowed to practice law in the state. And it can be admitted to practice either by obtaining the law license or being admitted to practice pro hac vice. What does that mean?
Vici.
Mispronunciation 1. Go ahead.
I actually just did this in Rhode Island. You're allowed to have the court recognize you as licensed for a specific purpose in a different state. So like I have a client who lives in Arkansas, but his company has been sued in Rhode Island. And so the way it works out, a Rhode Island attorney is involved because you have to have a sponsor that oversees you, since I don't know all the Rhode Island nuanced laws.
You don't?
No, I haven't done that before. Even though my brother lived there for like 6 years. Still don't
get
know
it together.
Yeah. And so I got admitted, they call it pro hoc. I got admitted pro hoc in Rhode Island so that I can represent this client up there even though I'm not licensed there.
That's pretty amazing.
But it's only for that one case. I'm not licensed to go now represent somebody in a contractual issue in Rhode Island.
Right.
I can't do that.
Well, because you're not even licensed with that state. And
Correct.
For some reason I thought that attorneys were like universally licensed, but you're not. You're only per state like anyone else, right?
Correct.
Ha ha ha. Let's go somewhere else.
There's a thing going around right now. I'm not real interested in it, but you can get a license recognized in like 31 states, and I think Arkansas is a part of that. I'm licensed in Arkansas, Oklahoma, and Texas right now, but I don't know that I want to be licensed because a lot of times
I need you to stay on our show. You're not going anywhere.
Yeah.
But
a lot of times I get calls from somebody out of state that's got something in another state and they want to know if I practice there and I don't want to do it. Nope, because I can say no.
Nope. Yeah. Well,
nope, not licensed in Missouri. Sorry.
That's misery. The other part that makes me laugh about this whole situation, though, is that you probably I would practice in Texas just to remind them who beat them recently this weekend.
That's right. Wear my Razorback polo in court.
Yes, I love that. Oh, do that, please, the next time we're in court. So also it does... What is also important to me in this conversation is that brokers often think that because they are brokers, writing contracts, executing contracts is okay. So let's go to the general addendum. Have you ever seen something put into the general addendum that violates this rule?
All the time.
All the time. So it's like that's I mean,
because
what else besides personal property?
There are specific items. Like a lot of people will use the general addendum to change the closing date.
But we have a closing date modification.
Exactly. But that's not wrong to use the general addendum just to plug something in, even if you have another form that accomplishes the same thing. I see it all the time where people use the general addendum.
Like someone will use it instead of a counter because it's just like, let's just get it under contract.
There will be some people that will use the general addendum to extend a contingency or extend an inspection date by agreement or require a deposit. Those things are okay as long as you're just doing extensions or requiring additional things that would have otherwise been allowed under the contract. But adding things that are not contemplated by the contract that was originally executed is where the problem arises.
So what else have you seen go into something that actually violates the violates the rule where you cannot practice
The biggest one I've seen is the one that I referenced at the beginning of the show. The reason I said you've got this list of names is because I represented an agent one time who, in this paragraph 30, had a deal. It was actually in a listing agreement, but the listing agreement also has this same blank provision deal.
Exclusive right to sale, new agent.
Yes. And at the end of it, there was this deal of the people on this list are the only persons who are the persons that I've contacted. And if one of them purchases the property, I get a commission. If it's anybody else, I don't. Well,
they should have had a freaking permission to show, sounds like.
Exactly. You get this list and start going through it, and they take the deal and it's names. There's like 100 and something names on the list. Well, you get into the issue, and the person that ends up buying the property is the very last name on the list. And so the seller of the property immediately has a lot of question marks because it's like 3 months after any contact with anybody has occurred. It's just kind of been sitting there, and all of a sudden the very last name on the list happens to be the person that submits an acceptable offer. It could have happened. It could have been that way.
I've seen Stranger Things.
Yes, but it just raises a whole lot of red flags when you've got 150 plus names on a list. You've had to use the back of the page to write names on everything else, and the last name is the one that ends up with it. And it ended up in litigation over the commission because it was like a $3 million piece of property.
Which is probably a $175,000 commission.
Yeah, so it's a big commission.
Deal. Yeah, and I really think that
we never got a legal resolution on that case for a determination. The guy who
settle?
We did ultimately, but it's because the guy that was the seller passed away in the midst of it.
That's complicated even further.
Yeah, and so we ended up filing a claim against the estate and all kinds of things, and they finally called and said, look, the rest of the family doesn't want to deal with this. Let's try to resolve it, and we got it resolved. But that's an example of that caused a huge disaster when there were 20 other different ways we could have done this and organized it to where we wouldn't have had that problem.
Well, and just as a disclaimer, from experience, and when I first started in the real estate industry, I was actually very fortunate because the broker of the company that I started at, there was actually the very, 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 very first broker who held my license no joke. Because here's the thing, when I started in real estate, the reason why I got the license was because I had been an appraiser for so long, and I had so much knowledge about what the bank thinks about property, what is it worth, and I don't know if you noticed, but I'm pretty good at marketing and advertising. So the point was, when I started not advertising, Randy, but I'm pretty good at branding things. So end of the day, I am sitting in my house one day and I'm talking to my husband about, I have this idea and I have that idea. And he's like, just go get a real estate license. Just go get one, and put it somewhere. I thought you could just get one and put it in your pocket, but it turns out you have to have it with a broker. So I'm learning this at the time, and I go and get it. And it's like 2013. I don't think I used it till 2017. But the first guy I ever hung it with, he was such a stickler for the rules, and he knew everything about everything. And I gave it to him. He'd been in the business, I think 50 something years. He's still practicing, one dude. And he literally broke me down into, if you're doing a closing date modification, you don't use a general addendum. If you're doing an exclusive right to sell, you do an exclusive right to sell or a non-exclusive right to sell, depending on the circumstances. But what the issue you just brought up to me tells me that you should have used a permission to show. That agent should have used a permission to show, because that actually has a space in it that says, here are all the names of my potential buyers. And it allows you to amend that with a date stamp. And thanks to the copyright laws and the fill in the blank style of the forms we have, really would have avoided all of that litigation. So I'm very grateful for that, having that training. And if you're a new agent or a broker, make sure that you're implementing the understanding that we have forms for almost everything at this point, right? Except for earnest money. We can just cut that one right out.
Yeah, we don't need that. Or the deposit.
Yeah, we don't need that. Non-refundable.
We've already done an episode.
No offense, guys. We've already done it, but I'm just mentioning for that we don't need it. Horns down. Yeah. Is that how you do it, or this?
No,
this?
That's it. Yeah.
Okay, I'm just making sure that I tell them they suck legally. Okay, so moving into the unauthorized practice of law and the problem of multiple client loyalties. This is actually written by someone in your family, but I don't know if you've read it. I'm just kidding.
Probably not.
It says there's been several decisions handed down by the Arkansas Supreme Court that, which also with the Real Estate Commission regulations, that every real estate professional in the state of Arkansas should become very familiar with. The unauthorized practice of law deals primarily with the question of when real estate agents and brokers improperly invade the province of lawyers. They subject themselves to being sued for the unlicensed practice of law. So it says that this can subject the agent or the broker to lawsuits. So again, coming down to that broker signature, when people send you a contract in the middle of the night and you just sign it and you don't, and you don't
look at paragraph 30.
30 is the biggest piece of danger for me. And in the commercial contract, there's a lot of things as well. The real estate contract that is commercial for the area, it also has a lot of spaces in it where you can fill in the blank. And when you get willy-nilly with that keyboard, you're just kind of opening yourself and your broker up to a lot of things. Now, it says right here that the determination of what real estate agents and brokers can do to finalize negotiations and transactions received a very cold shoulder from the Arkansas Supreme Court the first time the question came before it. It says, we'll know it when we see it. So that kind of, explain that to me. We'll know it when we see it.
Yeah.
Yeah, because there's no regulation by this. Mm-hmm. I mean, break that down for me. We'll know it when we see it.
I mean, they're going to be able to determine. There's a difference in negotiating things like a purchase price or negotiating things that are contemplated by the contract that's already been drafted by a lawyer and going way outside of what those documents are intended to accomplish.
And the scope of your abilities, really.
And that goes back to the thing that we just talked about of adding these names to a list with no other provisions about what's supposed to happen, if there's going to be any oversight, if there's going to be any notification when a name is added to the list, if there's going to be any communication that has to be maintained. None of that is in there. And that's what they're talking about. That is exactly what the Supreme Court is talking about, is if we can't justify a reason for why this particular provision was written in an agreement because it's so deficient on its face that it's clear that someone did something that they shouldn't have done.
Ooh, that's like talking about the stingray.
And that's where, it goes right back to it. The Supreme Court's going to look at that and go, there's so many problems with what you just did. You intended to do something that you're not licensed to do, and it's very clear on its face.
I think that comes down to ambiguity, as you said at the beginning, because it becomes down to one of those things that, like, I didn't even think about some of the questions you asked me. A lot of times we'll be preparing for a case, and I'll be like, this is my answer. And you're like, no, it's not, because you have to think about this, and that. And that's your job as the lawyer, which I think is kind of drives that point is, I like the word attorney better than lawyer, but anyways, it gives you a situation where you as an agent, really the best thing you can do for yourself and your broker and your client is to involve somebody if you have any question in your mind about whether or not what you're doing is okay.
There's a lot of times that if someone has a question for me or needs a small provision drafted to cover something, that I just do it. I don't even charge them for it.
I'm just laughing.
You want to be sure. You want to be sure that you get it right. But here's the thing about even if you have to get a lawyer involved, whether it's me or somebody else,
it's you.
If you pay for an hour of time, if you pay $250 for an hour of someone's time to draft a provision, have a conversation with you, have a meeting with you, look at the contract that you've got, draft a separate agreement. That's a whole lot cheaper than the $10,000 you're going to spend in the resulting lawsuit.
Now, listen, attorneys will be helpful for that first initial hour like you're talking about, and they may charge you by the hour, and that's really nice of them. But what they don't do is when you go to court, they don't limit those costs. They're called attorney's fees and costs, and because they know they can get them from the damages, they're not real concerned about billing it, no offense. But that's the whole thing. If you're going to have to prepare for it and fight for somebody, it's going to cost them a lot more money when you're on the other side of a tangle than before you ever start putting yourself in that situation.
You can't get involved in any piece of litigation over any reason for less than $5,000. It's just not possible.
No, I mean, don't even file a lawsuit. So what's funny is,
sometimes you don't have a choice of whether to file one or not. If you get sued, you have to defend yourself, period.
Right.
You don't have a choice.
But people can sue you for all kind of things, and that way you open yourself up to that, though, when you don't
do
verify.
something like this, yeah.
And you don't verify in your contract all the different things. So it says right here, and these are two pretty informative little sections right here. It says the questions raised in block were again addressed by the Supreme Court in a case called Creekmore versus Izzard, where the court modified its holding in block and stated that, quote, a real estate broker, when the person for whom he is acting has declined to employ a lawyer to prepare the necessary instruments and has authorized the real estate broker to do so, may be permitted to fill in the blanks in simple, printed, standardized real estate forms, which we have, which forms must be approved by a lawyer. It is being understood that these forms shall not be used for other than simple, is there such a thing? Real estate transactions, which arise in the usual course of the broker's business, and that such forms shall be used only in connection with real estate transactions actually handled by such brokers as a broker, and then without charge for the simple service of filling in the blanks.
Yep.
I just like how you're just like confirmed.
That's
No
exactly,
questions.
that's what we do today, though. That's what
Right,
you
but
do
it's a-
today when you do a transaction. You follow that very rule right there.
If I'm a brand new agent, though, and I hear that, I'm like, well, that was a lot of words. What does that mean? And what that really
It
means
means
is
you're allowed to use the ARA forms. They've considered it not to be the
complex.
the unlicensed practice of law to fill in those forms, check the boxes, handle a transaction in the normal course of business that you would. The moment that something unusual arises, you can't use those forms anymore. Or you can use the forms that are modified with language approved by an attorney.
Well, I'm sorry, but item 30 is a dangerous place to hang out. So just real quickly, I need to go ahead and mention that the Supreme Court defines a simple real estate transaction, just following that in this article, and says that a simple real estate transaction is those which involve a direct present conveyance of a fee simple absolute between parties, which becomes effective immediately upon delivery of the title document. Such transactions do not include conveyances involving reservations or provisions creating life estates, limited or conditional estates, contingent or vested remainders, fee tails, easements or right-of-way grants, or any other conveyance of future contingent or limited interest. Break it down. I'm sorry, sweep it up, grooms.
Well, the one that stands out there to me that would be the most common is the easement. A lot of times, let's say you have a piece of land that's getting sold that you're buying, that's 5 acres that you're going to build your home on, your forever home, that you're going to build it there. But it's behind another piece of property. But so you've got a long piece of property, you're buying the back. A lot of times that deal will be negotiated where you're buying the back piece and the person who's cutting that piece out of their property is also selling you an easement across their property so you can actually have a driveway and get a vehicle back there.
Suddenly, it's not a simple real estate transaction
And all of a
anymore.
sudden, just because of that one deal of, hey, we need access to our property when we buy this from you, it's outside of the realm of that. All of a sudden now you have to have an easement deed or you have to have a deed that references the easement being created, and that's where a lawyer has to get involved. It's not simple anymore.
I mean, it just...
And that's not an uncommon scenario that I just described in Arkansas.
But it happens all the time, and I do not see people involve attorneys, and that's another reason why this is a great thing to talk about. And the whole idea of I hate real estate, I mean, honestly, we don't, but we do hate when things like this destroy a career. And they can. Because if you go to court and you get in trouble and you lose your license and or your ability to broker, let's say that your broker's license is stripped, but you could still sell property. If people Google you and find out your broker's license is stripped, it's kind of damning to your reputation. And if that happens because of a simple issue like this in the mind of, okay, I have these transactions, these contracts that are fill in the blank, but I typed into item 30, additionally, there will be an easement included in this contract.
Tell me what happens. Not necessarily even a license. You can get to the point where you have to file a bankruptcy case because you get popped with damages. Let's imagine you're an appraiser. Imagine the value of a piece of property that's a contingent 10-acre piece of property.
Contiguous.
And you sell, yes, I said contingent, contiguous. And you
it's contingent on your answer.
You own that, and you sell me the back 5 acres of that piece of property. But my agent, I'm not a lawyer in this scenario, my agent doesn't talk about an easement, doesn't consider access, or we do talk about it, but there's never a provision created. We close on our deal. You sell me the back piece of property, and then you refuse to give me an access easement.
So
what's my property worth that I paid, let's say, $200,000 for if I have no access to get to that property?
If we weren't on the air, I'd say, I'm just kidding. But seriously, nothing for the most part.
And so then I have $200,000 in damages because this person won't. I either have $200,000 in damages or I'm going to incur a whole bunch of legal costs and expenses trying to obtain an easement across that. And guess who's responsible for that?
The agent. really, because the agent's the one who executed
The agent is
everything.
at very least partially responsible for that.
Well, and the broker
that's a
for
large,
overseeing
substantial. That's a substantial damage and amount of money that goes into that. You could be talking $250,000 in damages.
Well, when you have a landlocked piece of property, you can't access it, can't get to it. I actually sold a piece of commercial property recently that had a lot behind it, and you can't get to the lot without crossing that piece of property, and there's no easement in place because they bought it in foreclosure. And I remember the owner said, like, this should be worth more because there's a lot behind it. I'm like, yeah, there's an undeveloped lot that cannot be accessed without an easement. You need a survey, which is going to be $1,500 in 45 days in this market. Let's do it. He's like, nope, let's just sell it. Let's put it in the contract. I'm like, okay, that's fine. We went ahead and bought sold two separate pieces as opposed to messing with it because it was that much more. However, if you're a new agent, you don't understand this. There's a good opportunity. You're going to make a mistake related to an easement, right-of-way easement, something along those lines. This also goes back to PSA, and a big thanks to Maurice Taylor at Vivid Real Estate Learning Center, who says that might be mad that I use this. Let me try to do my Maurice voice. Buying somebody else's property without a new survey is like wearing their underwear. You have no idea where they've been, and you're just walking around in their underwear. That's exactly what it's like to buy a property without a current survey, because the survey will tell you what easements are on the property.
Well, the other thing about the survey is if you don't purchase a survey or get a new survey done, then your title insurance policy is not going to cover any defects.
That was missing.
If you find out that the next door neighbor's house is 5 feet over on your property, there's not anything you can do about it.
We can't even go into that because we don't have enough memory cards to do it. I'm telling you, it's ridiculous.
We don't have enough battery or cards.
No, or patience. But the other thing I wanted to just bring up real quickly is
what else was on that list? That because we talked about easements and reservations. Like reservation, you've got life estate things. Like if you're doing estate planning, if you're trying to give. If you're trying to give property ownership to somebody
involving reservations or provisions that create life estates. So if you're creating any sort of life estate through the process, which a lot of people do,
or if the person, so in that instance, we can flip our scenario, and you're selling me the front piece of property and you're keeping the back. In selling me the front, you could reserve yourself an easement so that you can continue to access your back property. It's just the reverse of what we said.
If you're smart enough to know to do that, one. If two, you have an agent involved that understands it. Or if three, you contact Campbell and Groups and have somebody advise you to do that. But that being said, going back to this, what you just said, and this is, I believe, and I think agents should really pay attention to this, in the comma situation, what I call the common comma issue is right here. It's listing all of those things. Provisions creating life estates, limited or conditional estates. Bring it back. Do not include conveyances involving limited or conditional estates. So this is saying that if you're selling a property that has shared interests among owners, you're, again, not in a simple real estate transaction.
If it's not an outright, my property completely is going to you, and I'm not going to be your neighbor, I'm not going to be involved in this anymore, I'm out, then it's not a simple transaction under that definition. And
to be quite honest, it really limits the number of transactions of how many are done simply. Just by that
and there
discussion.
are more simple transactions than not simple transactions out there.
But not by as much as you would think.
No.
Because now all of a sudden you're also involving any other conveyance of future contingent or limited interest, which comes back to that easement, that operation, the house being over the line. All of those things are included. It also comes down here and talks about realtors should be aware that their negligence in preparing such legal documents may well be examined by applying a standard of care expected of attorneys. So if I'm going to execute a document along these lines, I have to be held to the same standard that you are. Mm-hmm. I don't have your education, just FYI. I know I'm really good at real estate, but I can't practice law. It reminds me of that time in the Jim Carrey movie where he's in the boat. I'm a pool man, not a doctor. Yeah. That's me. So multiple client loyalties. This is another one that's important, and probably the one we're going to close on because I really think people will probably reach out about more information related to this. This is in Regulation 8.5 of the Arkansas Real Estate Commission regulations, I believe subsection A. Not that I believe it. I saw it on this paper. It says in accepting...
I don't have it memorized.
You know what? That makes me feel better because if you did, I'd be like, what is wrong with you? In accepting employment as an agent, a licensee pledges to protect and promote the interests of the client or clients. This obligation of absolute fidelity to the interest of the client or clients is primary, but does not relieve a licensee from the equally binding obligation of dealing honestly with all parties to the transaction. If you didn't know, it doesn't matter, correct?
Yeah.
You have to know.
I've quoted that in multiple complaints and lawsuits, that very quote right there.
Yeah, and you probably say it really fast and angrily.
Well, it's because you get... It's off topic from this particular issue, but let's say that you've got a seller's property disclosure that doesn't disclose something, but the agent knows about it. The agent has the obligation to disclose that to the other side, even if it's against the interests of the person that they're representing.
PSA, this means if your property's been inspected from the time that you put it on the market to the time that it goes back on the market because it came out because of the inspection, guess what has to be included on the seller property disclosure?
The inspection.
All the items that you found out about on the inspection.
You got excited about that one.
Because I can tell you 1,000 times people that have done that, and I know for a fact that I love you guys, I love you agents, I love you brokers, but you're wrong about it. You have to disclose those things. Your seller, it's damning. I get it. You don't want, like, we all know who the best inspector is. We try not to say his name. He'll tear your house apart.
The real estate documents are not entitled to protect against that.
No. And the bottom line is, as seller property disclosure, you know, big BA over there, the home inspector goes in. And God, I hate it when he has the buyer. Oh, I hate it. I'm sorry. But he comes in and he rips my listing apart, little things. And then I have to go through my seller property disclosure, explain to my seller, I'm sorry, but now we know about this. And it doesn't matter if it's a little thing or a big thing. It has to be disclosed. And then that disclosure goes from 8 pages to 8 pages plus 3 to explain everything that I found on that home inspection. But it is my absolute responsibility as the fidelity holder here, or it's my absolute fidelity to give this to my client and to the other side and to everybody involved because I know it.
Essentially what that says is you can't tell a potential buyer, hey, my client's willing to take $10,000 less than what they're telling you, or they're willing to take $15,000 off of listing, or they're willing to pay your closing costs. It's not saying that you have to do something like that. It's saying that you can't lie to somebody. You cannot withhold information. You cannot tell somebody something that is untruthful to try to get them to buy the property.
Yeah. Shocker. I'm just saying. People don't understand that. So anyways, we're running out of time here. Our director is standing up, which means something is desperately wrong. Yeah. Anytime he gets up from the editing station.
I think his beard fell off. He's been pacing so
I didn't know he could grow one. That's exciting. Yeah. Oh, that was mean. I'm sorry. Okay. We love you. He's going to cut us off right now because of it. But anyways, closing on that. When it comes down to it, you have to disclose. At the end of the day, you cannot write it down and expect it to apply as does the law because you're a real estate agent or a broker, not an attorney.
Correct.
So we're going to rule on this.
We're going to not practice law without a license.
Right. We're going to go ahead and let an attorney hit a judge's gavel light of that.
That's right.
All right, haters. See you next week. That's actually my favorite thing right there.